G'day, Tom. Welcome.
Andrew, good to be back.
Yeah.
Didn't forget about me.
Back from the dark side, doing litigation work on estate work.
It's good to be back where I belong.
Well, look, we're talking about flexibility arrangements and reasonable business grounds for actually refusing flexible. But that's the main topic for today. So we'll come to that a little bit later. But I thought what we might do is just start off with Latham's amendments to the New South Wales Bill amending the occupational health and safety legislation to actually highlight people who've been repeatedly dangerous, or organisations that have been repeatedly dangerous. And the idea is really to raise the profile of WorkSafe as a prosecutorial regulator, but also to name and shame.
Yeah, it definitely seems like a bit of a name and shame policy, where high-risk workplaces identified by Safe Work will be listed on their website, it seems like.
Yeah, it's just nonsense really, isn't it, Tom? And it just shows you what happens when politicians who want to make a name for themselves get hold of a piece of really important legislation and start fiddling on the edges and try to turn the regulator into a sort of soapbox. And it's sort of got to stop. Like, there's no upside in doing this. The regulators publish their decisions.
Yeah.
They're there for everybody to see. The media can grab those decisions where they actually refer to past misconduct in, and they can actually agitate the issue.
Yeah.
But politicising the regulator.
And this type of criminalising safety is not productive.
No, it's not, Tom. We've talked about it before, that one of the difficulties, and we talked about this with the sentencing review, is people keep dealing with safety law like it's traditional criminal law. And in fact, and like in traditional criminal proceedings, you get the media grabbing hold of young kids causing violence from a particular national background. They're evil children type thing. Same sort of stuff is starting to happen in safety, where there's this idea that there's a bad person and a good person. And it's part of the nature of sort of media discourse at the moment, that we polarise, don't we?
Yeah.
If you don't agree with me, you're a terrible person. You're not just wrong, you're a terrible person. But in safety law, commonly, these are good people who make errors which cause harm to other people. And more than the person who is the victim of that harm suffer, nearly everyone suffers around it.
Yeah.
And so when we have nongs trying to actually create a criminalised version of what is safety law, what it means is that the people who run businesses feel hurt and angry about it. They feel resentful. They've suffered pain. They've suffered loss. Their lives are not made easier by injuring someone. They're made much worse because they're humans. And they're not out there trying to steal from them. They're not out there trying to murder or assault them. They're actually trying to create a business.
Yeah.
So as you say, the narrative that sits behind this is deeply concerning. And it's sort of more concerning that, once again, what we're having is bits and pieces from around Australia doing bits and pieces of things that are different, which means the cost of actual compliance across Australia is much higher, because you're now starting to get back to the old world of safety, where there is different regimes in every state and territory.
Yeah, I don't think I was around for that, but...
Okay. So I am feeling a bit old, aren't I? Okay, let's move on. Tom, really interesting case, safety case.
Yeah, Safe Work, New South Wales v Pendleham and Bacon.
Yeah, Pendleham and Bacon.
Yeah.
You have a rough idea what they do. Yeah, they're a chicken farm.
Yeah. Yeah.
So this is a pretty interesting case. Sorry, it's a bad joke, wasn't it?
I like that.
But this is some people who fell through a skylight.
Yep.
Yeah. And the employer in this case had said, look, be careful, don't fall through the skylight. They'd set up a number of controls that did exist. There was clarity around what was the expectation. Do not go on the skylight.
Demonstrated how to correctly do it.
Did it, all that sort of stuff, and made them clean and do things from a distance that meant they couldn't fall through it. Okay.
Yeah.
It went before, increasingly, the sort of leading judge in WorkSafe prosecutions in New South Wales, Judge Scotting, who used to represent WorkSafe previously as a barrister. And interestingly, his judgments have become more mainstream than what I would have ever expected after running cases against him. But that's not the point of the story.
Yeah.
But the point of the story is he looked at this, and very serious charges of gross negligence and recklessness were made. And he made, I think, the really telling point that, no, these people weren't indifferent to the risk. They weren't grossly negligent. Actually, they had a system which, had it been complied with, would have prevented the injury. Was it sufficient? It was a bit inadequate.
In what sense? What would you have?
Oh,
them
well, in
do?
other words, harnessing, putting up barriers to prevent people from falling. They're all the things that are expected when you work at heights.
Greater supervision, perhaps, for an inexperienced worker.
Those types of things. Greater skills around demonstrating their competence. But what he said is, look, it may have been inadequate, but it certainly wasn't reckless, and it certainly wasn't gross negligence. And the mistake here is the regulator went into fight with its boots on and charged them with very serious offences. Had they charged them in breach of primary duty, they would have got home.
Yep.
But I think that tells us all where our regulators are at the moment. If you fall from heights, motorised plants, psychological hazards, they're going to go for big charges because they want to land it, and most people plead guilty. These 4 defendants didn't plead guilty and they won. So a really interesting case. Anna Booth, the Fair Work Ombudsman, has launched an investigation into the construction industry, Tom. What's that about?
So this has been prompted by, I think, a video that was posted on, published by 60 Minutes that showed...
Always good when government respond to 60 Minutes, don't you?
Yeah. Very, you know, you're right at the source there. In response to a video that was published about depicted a female worker being mistreated on a CMFEU site. And much like the Channel 9 investigation that's come before this into sexual harassment, I forget the name of the other one.
Merivale's the other one.
Yeah.
Look, can I just say there's a mischief that sits behind why this has occurred. I'm not criticising Anna Booth. She's actually a great person who's the Fair Work Ombudsman. But this is driven by a Labor government who doesn't want us to look at CFMEU behaviour. And if we looked at Channel 9, they appoint this very well-known external investigator. You look at Merivale, they appoint this very well-known. And it looks like they're actually instituting a control. But if we look at reasonably practicable, is there a hazard that exists here? Yeah, there's a video of the hazard.
Yeah.
What's the level of risk beyond that incident? And are there other hazards? I don't know. So what do? I go into a risk assessment. That's where the investigation sits. And the investigation identifies the hazards and the nature of the risk and recommends controls, the third element of reasonably practical. But since spin doctors have taken over the world of safety and sexual harassment, they've realised this way of delaying public awareness of something by saying, no, we're looking after it because we're investigating. I'll tell you what, when you are the victim of sexual harassment, you don't feel better by being investigated, okay? You feel better by the person involved being got rid of, by there being pure and proper controls that are in place. So this is the Albanese government trying to not be seen for doing nothing about the CFMEU.
But doing nothing to help.
Yeah, but doing nothing to help. And by the time this is eventually reported on, it's likely they won't be in government. If they are, they'll be a minority government. And what they've done is taken the focus away from what they see as their Achilles heel, the union movement. Rather than have the courage and say, we will not allow bad behaviour in our workplaces. By the way, it's pure union belief system. We will not allow bad behaviour. We don't care whether they're unions or employers. We won't allow it.
And you have the videos.
Yeah, and stand up and let's investigate this, but let's do something for that woman right now.
Yeah.
But the other thing is, let's not drive policy by 60 Minutes. This is information that they are well and truly aware of the risks for many years on building sites of how women are treated on building sites. And it's only when 60 Minutes raises the flag, they go, we better get Anna Booth to investigate that and let's get rid of that one. That's off the page. Whew, I feel so much better.
Wipe the hands.
Yeah, just remember investigations are actually meant to be done quickly and they're meant to introduce controls very quickly. This is designed to be as broad as possible so there'll be no report for a year to take the heat away from them. Tom, we've talked a lot about the use of risk assessments which are just inadequate. So there's a process, they sit there, they've got all the popular jargon, the take fives, the zero harms, all the names which are relatively meaningless and don't create any safety. But we've had a great case, which is Safe Work New South Wales and Dan Ray. And this is a case which I think strikes at the heart of the type of folly that does exist in safety land.
Yeah, so it's a...
you want to do it? Yeah, you go for it.
Sorry. Shall I?
You know, off you go. No, you do it.
This one is a couple of years old now.
The koala.
I like I've been here for a couple of years. So it's, in 2021, a waterproofer and his or her apprentice were working on the roof when some adhesive liquid caught fire as they left a heat gun on nearby.
Yeah.
And it's erupted in flames and burnt one of the workers quite significantly. Prior to that, they'd been asked to do a sort of a Take 5 risk assessment.
Yeah, they had that. So what they had, so there's some parts of this which seem commendable, and I'll come back to why it seems rather than it is. The idea of having an app on your phone which takes you to a critical risk and tells you what to do, great idea. Putting a risk assessment on a phone that you can swipe through the screens and ignore parts, and you can work without ever doing it, so no sign off on it, really takes you nowhere. Having a SWIMS which doesn't deal with the critical risk of having a heat gun next to solvent, the biggest risk there is a complete and utter failure. Having a Take 5 idea which says, okay, stop, think, reflect, it takes you nowhere unless you're identifying critical risk. And modern safety is not about filling out 40-page SWIMS, because everyone knows it doesn't work. Everyone knows, even if they do fill it out, it's just tick and flick.
You can skip through, which is...
What you need is to say, look, you're going to work at heights, so do you have a harness? Are there proper barriers from you falling? Those type. Okay, there's one. You're going to be using a solvent, and you're going to need to use a heat gun. Solvents are inherently combustible, and when they combust, they don't go do-do-do-do, they go boom. Okay, and they spread solvent on you, which continues to burn on you while you're there. Risk 2. Okay, well, you better know what to do. Yeah, keep the heat gun away from the solvent. Okay, good. You're not going to catch fire. Like, it needs to be as simple as that. So every person that goes up in that room looks at the 3 or 4 critical risks, and they know absolutely what they must do. But what happened here is this heat gun just sat there until eventually it did combust. Because nobody, because it never happened before and they were desensitized to the risk, nobody did anything. And yet we have a serious injury.
As is so often the case.
Yeah. And so I guess, when Tom and I put this case on, part of our argument was really having a safe system is not the description of what is safe, nor is it proving that people are competent in that. It is demonstrating that people do what is competent and required every single time.
Yeah.
So it is a state of knowledge rather than a piece of paper.
Yeah. And you're so often critical of that sort of approach to safety.
The evidence is overwhelming. If I go to this business, I'll find really good policies and procedures. They're just too big and nobody can carry them, let alone read them. Safety has to be nimble, available in the language and the style of the people who are using it, and it must tell you what those critical risks are and how to manage them, because if you manage those, you manage the rest.
Yeah.
All right. Tom, AMP went through a zombie agreement process. Union tried to maintain the zombie agreement, and it failed because it was less than the actual award.
Yep.
And then AMP issued a series of contracts. And the union, understandably, a bit upset with some of the concepts that are in there. And can I say it's very common to have medical assessments in contracts, okay? It's pretty common to have an annualised salary.
What about continuous video surveillance?
Not common at all, really, Tom, is it? And can I just say the financial, post-COVID or during COVID, the financial institutions got into incredible trouble, the large banks, the large insurers, for having keystroke surveillance to make sure someone was actually at their computer. So it told them if they weren't tapping at their computer. Now, it's pretty stupid thing to require of someone. I could probably teach Terry, my dog, to sort of tap a computer. That would probably do better work. But here it's actual physical surveillance, and these are people working remotely in their home. So the privacy issues are, yes, your workplace when you're working at home is a workplace, but who thinks actually physically surveilling someone is a good way to get good work? And AMP have shown a lack of judgment through other prosecutions. They've more recently been involved in other investigations that have been involved. But this is real tin ear stuff, isn't it? This is putting something in where you know your workers will be offended.
Yeah.
Workers probably wouldn't have been offended by the medical assessment part, wouldn't have been offended by annualised salaries. They're not things, but saying I'm going to watch you through your computer, that's bizarre, I reckon.
Yeah, and it's like you were saying before, do you want me to think that you're interested in me being the best lawyer I can be, or that I'm just showing up to work?
Yeah.
Or that I'm at my desk.
That's right.
No matter what I'm doing.
And look, can I say to you...
What are you more interested in?
Yeah, what how do I want it? So can I measure, and your comment when we had this is, but it's easy in law because you look at productive time spent. Well, the truth is I look at productive time spent, but also quality of work. And if you're not performing, I can see them in either place, okay? But in Shoreland, in financial institutions generally, production is very easy to measure. In fact, there are, in all financial institutions, quite deliberate KPIs which can be measured on daily, weekly, monthly basis. Output is a much better method of measuring performance than staring at someone.
Yeah.
So why would you choose an unsophisticated, blunt method? Because what you're doing is saying, I don't believe you're working. That's all physical surveillance says. I don't believe you're working. And what's the message to workers who see that? Well, I can't say it because we're live at the moment. But it is stick it up your ass.
Yeah.
It's just, if that's what you think of me, how degrading.
It does nothing but erode trust, really.
Yeah, and when you erode trust, you damage performance. So it's crazy. Okay. Tom, our main topic today is flexible work practices.
Yep.
Got a really interesting case of Paper Australia and Anthony May. Guy who's worked for 13 years in a flexible working arrangement.
Yeah, to help him allow him to pick up his kids from school and whatnot.
Yeah. He's got 3 children. Paper Australia have said that's fine, and one day they get a new manager and they say no.
Yep.
So he formalises the request and they say no.
Yep. And the reason they did that was because they said it was inconsistent with the enterprise agreement.
Yeah, the enterprise agreement, including during that 13 years, described shift arrangements, and this person as a team leader fell outside those shift arrangements.
And it's worth noting here that under the Fair Work Act, if there is an inconsistency between a flexible working arrangement and an enterprise agreement, that can be a basis for rejecting it.
Interesting. Sort of yes and sort of no. So up until this time, there's absolutely no doubt that the money provisions of the NES always beat what's an enterprise agreement. They form part of the boot test. So if we try and pay people out leave when they shouldn't have it, if we reduce amounts of leave, if we do all the things NES protects, you can't erode that in an enterprise agreement. You can't change what is a stipulated provision. The NES is the rule. You can only amend above it. Okay? But no one had ever really thought that the flexibility provision, although it is a NES provision, would hold a priority, and certainly Paper Australia didn't think that. They wouldn't have run the argument against enterprise agreement. And understandably, Paper Australia said, look, he's a team leader and he can't be there at times when he needs to lead.
Yep.
And what the Commission held is, well, no, the National Employment Standard is the rule. You've approved it before. It relates to responsibility, to what's protected under flexible work arrangements. And there's no good business case, no reasonable business case that says it fails. And history says it's actually been going okay.
13 years of it.
Yeah, 13 years of it. So it's a hard case to run, isn't it? It's hard to say we've done something for 13 years, but now it's impractical.
Yeah.
It's not even a wise thing to say, really, when you think about it.
Is there a better way they could have run that?
Well, look, we weren't there, were we?
Yeah.
I don't want to criticise too much without being there, but whenever you're before a court, courts are very practical. They're although they're judges, in a way they bring a lay mind to it, particularly good judges, and they'll go, you've been doing this for 13 years, why is it a problem now?
Yeah.
So if your argument is, look, we've done it at considerable expense, it's caused problems, we've needed extra resources, there are safety issues that arise because he's not present when we actually need him to be. They had to run that argument, they had to answer the question for the judge, then the judge probably would have gone, it's a long time they've worked for you to try and make this reasonable. No, this is not a reasonable request. But you've got to answer the factual question that's agitating the judge.
Yeah.
And it's very rarely a legal issue that's agitating a judge. They're going, there's something not sensible about what your argument is. And they then become quite deaf to quite good legal arguments. So I thought it was interesting. I thought the next case, which is a much older case, which is Mark's case, is an interesting case.
2025, actually.
Yeah, beg your pardon?
This one, Mark's 2025.
Mark's is 2025 as well. I thought it was an older case. There you go.
Unless I've written it down
maybe
wrong.
I think you printed that out wrong. I think that was 2013. But anyway.
This might be my last.
It's good. Toy, if you can just make a note that Tom's put down the wrong date of a case again and then blown me up for it. Okay, so By the way, we don't have to delete this part, just for the camera. That's us just having a shot at each other. Tell me about Mark's case, because I think this is a great case.
Yeah, so in this one, the worker who was a nurse was already allowed a 9-day fortnight permitting her to work 3 days from home because she had a rather large commute to work, 150 Ks. Then she submitted a further request because she wanted to work 4 days from home and have a slightly different start time on a particular day, which the employer rejected, saying that it had adverse effects on her colleagues, and she was required to be present at work to fulfill some of her duties. And for that reason, there was a solid business case for saying no to her.
And she quite properly raised this. She said, but this is just a leadership preference. This is not about operational requirements. And the reason we chose this case is it talks about the soft issues of being present. You know, it's the relationship formations, the able to make decisions, it's the ability to lead on particular issues. It's the importance of being physically present, what it does. But it also means that your lack of presence, if it casts duties onto other people, means that it is unreasonable. And they are very powerful business requirements to say, if your absence will increase the load of work upon other people and the soft issues around your performance will be eroded by working from home, then being at work is critical. And I think the reason I like Mark's case, it deals with a lot of the arguments about working from home as well as flexible work. It shows that business requirements are not only, do I put load on other people, can I do my job, but what is the impact on my performance if I'm not present? And what is the impact on other people's performance if I'm not present are relevant matters. And if you document and can demonstrate that, you've got business requirements. So I think a fascinating case.
Yeah.
Why don't we give this a bit of a run with the case study? Yeah?
Yep, let's do it.
Come on, over to you, Tom. Hit the case study.
All right. So Millie had worked for Moore & Makers for 13 months. She was 56 and had a history of mild anxiety symptoms, which her GP had treated with buspirone for over 10 years. She had an excellent attendance record. Her husband, Ted, had just retired. He had some back issues that forced an early retirement and needed help dressing in the morning, mainly with doing up his shoes. Millie wrote and requested a flexible work arrangement when Ted retired. The changes from the original schedule of 5 days a week, 8:30 a.m. to 5:30 p.m., included a late start at 9 a.m. to help Ted get ready for the day, and the option to work from home 2 days a week to be around him. This request was approved. Millie worked on the IT help desk and did some internal consulting for Moore & Makers projects. However, she struggled with project work because she was remote, felt isolated from project groups, and felt left out. Her anxiety condition deteriorated and she sought a new flexible work arrangement that involved working from home every day on the help desk, but no longer participating in projects.
All right, so the first question was Millie eligible to make a flexible work request? So what are the tests of what factors are alive to being able to make a request?
Yeah, so the Fair Work Act lists a number of factors that can enliven that the opportunity to make a request. One of them is if you're 55 years or older.
Yeah, pregnant, well, she's not pregnant.
Pregnant. If you're a carer for someone in your home, a family member or
So
otherwise.
a good question here is Ted somebody who requires care in a caring responsibility? The test is a lay test that sits in the legislation. It's not something which you have to prove disability.
Yeah.
Just that you have to care. So it could be getting children to school, could be doing Ted's shoelaces up.
Yep.
But on the evidence that we've got here, there's not a huge caring responsibility. So what else could it be?
The fact that she has a disability?
There's an argument that she has anxiety, but it's not being, at this stage, it's not really shining out. But yes, anxiety is a disability.
Yeah. The 55 or older.
And 55 or older.
Yeah.
Okay. So isn't it great? You know, I'm considerably older than 55 and I think I should put in the flexibility.
Yeah.
Well, what happens at 55? Why do you need flexibility at 55?
I'm not sure. I'm a fair way off that, but I would think I would. Well, what do you think?
I think it's designed to make you have a better life.
Yeah.
I think if you find flexible work and work in law, good luck to you.
Yeah.
Okay, so that's good. On what grounds? As Moore & Makers decided to oppose it, what are they required to do? Now, part of this, Tom, is the process. So you've got to consult with the person first.
Yep.
you've got to actually then provide a written response within how many days?
Within 21 days, and that should include the reasons for the refusal,
Yep.
stating what business grounds that refusal is based on, and you have to show some link between those business grounds and the request that's been made.
Yeah. Can I just say, take some time over that.
Yeah.
Be a bit careful about it. But you've seen with Marcus's case, you've seen with May, basic caring responsibilities will get you across the line. You've seen over 55 legislatively gets you over the line. So what is it about that person's role in being at work which influences the way work is done? Does it create a burden to someone else when they're not there? Does it mean the function of how you perform as a team is eroded by the lack of presence? But you've got to think laterally. But they're real questions, because when a leader is not present, or when a person is not present in a team and teams are talking together, they don't function as well.
Yep.
So there is, I think there's some interesting argument to have here to draft out the grounds, which brings us to the third question. Did the original flexibility arrangement create risks under safety, discrimination and workers' compensation?
Well, I think there is a clear safety risk here. Last week we were talking a lot about psychological hazards.
Yep.
Well, recently we have. And this woman, Millie, clearly has an anxiety disorder, and her arrangement is causing her some distress. So clearly there's a safety risk there.
So you've got to intervene at that stage, don't you? So Section 22 in Victoria and like provisions say you've got to do everything that's reasonably practical to monitor someone's health. You're seeing her health deteriorate because to actually manage the projects on her current flexible work arrangement is creating stress for her. So if she's at work, it wouldn't create stress for her.
Yep.
But when she's at home trying to do it or trying to fit around it, she's struggling with it. So can you go back to a flexibility arrangement and say, look, we're not happy with this because of safety concerns? Absolutely.
Yep.
Do I have to do something because I recognise that she has a protected attribute under discrimination law? Yeah, look, you can tell she's struggling. So at that stage, Section 22 of the safety legislation says you've got to do something. Discrimination law says, no, you've got to intervene and adjust. You've got to make sure that there are reasonable adjustments that meet the nature of the disability that arises. You've got to address it.
I wonder how aware they would be. That's it.
Well, see, under Burke and Suncorp, if a reasonable person could observe the changes that are occurring, you're deemed to have that knowledge. That was a general protections claim.
Right.
And it changed law in 2015 away from Tom has to tell me he's got a problem to if I, a reasonable person, I observe Tom's having a problem, then I must intervene and act because that's what the safety law requires. So we've changed a lot in 10 years' time. It's been a big change. All right, last part, workers' comp. There's no performance management going on here. So the test is not an objective test. If she experiences distress, pain and becomes unwell as a result of a workplace arrangement she requested, it's compensable. Her claim will be accepted because it's the subjective experience. So I just want you to remember there are two different tests. The test is, did work cause it?
Yeah.
Yes. So tick that one. Then is it subjective or objective? If it's not performance management, it's subjective.
Yep.
Therefore, if I experience a mental illness as a result of the work that I'm doing, win. Compensable.
So what you're saying is even though she requested this arrangement, they've condoned it.
Yeah, and so it's compensable if
Right.
she suffers as a result of it.
Because that was confusing me when I read it.
No,
I was
no,
like, she's
that's-
asked for this sort of thing.
But I did in a hurry. It wasn't helpful, Tom. I got to own some of that.
No.
Okay, now, if Millie said she felt unsafe in the current flexible work arrangement, and Moron Makers said she was directed to continue, is there any workplace law risk in doing so, and what would it be and what steps do you need to take?
I'd say absolutely. If she's already experienced
told
it.
you.
She's already told you that she's her
You're
own
on
symptoms are
notice under
deteriorating.
safety law, aren't you?
Yeah.
Yes, safe work environment, Section 21.
Yep.
Safe system of work, safe supervision, they're all gone.
Yep.
Section 22, monitor her health. Yeah, you're not doing that very well.
No.
So you've got to intervene. And I guess part of why we did this case study was to say, the moment you're on notice of someone having a mental health related issue, whether it's a disease or whether it's diagnosable under DSM-5, doesn't matter. The moment you're on notice of it through an observation or through someone telling you must intervene.
Mm-hmm.
You must find out and determine. And that would be through having her assessed, speaking to a general practitioner, but saying, look, here's a job, This is what she's doing. This is the expectations and needs for her. Can she manage those?
Yep.
But if you don't do that, it's just per se liability.
Yep.
Okay. So look, I thought fun case study today.
Yeah, I liked it.
I told Tom Moron Makers is spelled more MORE hyphen on hyphen makers, but I wanted Tom to sort of get that it was actually about morons.
Yeah.
But he didn't.
Maybe our audience are a bit more switched on than I am.
But then I always put in a word that tries to throw people every
Yeah.
time. So Tom did pretty well, I think. Okay, mate, thumbs up. Thank you very much for having us. See you later.
Thanks.